सभी विद्वान साथी, ये मेरा सौभाग्य है कि मेरे को इस अवसर पर यहाँ पर आमंत्रित कर एक तरह से मुझे एक अवसर दिया, जिस अवसर को मैं संजोग ही समझता हूँ। अवसर कॉन्स्टिट्यूशन और एडवोकेट्स डे के कमेमोरेशन के लिए भले ही, लेकिन इस अवसर में चार चांद लगाए एक घटना में, जिससे इस अवसर का सेलिब्रेशन असीमित हो गया। और वो घटना संजोग है या ईश्वर का विधान है। कॉन्स्टिट्यूशन डे की सेलिब्रेशन आज आर्टिकल 370 की जजमेंट के बाद एक अलग ही एहसास दिलाती है। कॉन्स्टिट्यूशन का रियलाइजेशन जो इस जजमेंट से हुआ है, शायद किसी और कारण से कॉन्स्टिट्यूशन की महत्ता, इसका अंकलन किसी और घटना से नहीं हो सकता। तो मैं आप सभी को इस अवसर पर और इस जजमेंट की प्रोनाउंसमेंट पर हार्दिक प्रसन्नता व्यक्त करते हुए इस अवसर पर यह कहना चाहूंगा कि संविधान, जिसको हम एक बाइबल के रूप में या एक गीता के रूप में या एक कुरान के रूप में मानते हैं लीगल फील्ड के लिए, इसका मूल्य अवलोकन के बाहर है। कॉन्स्टिट्यूशन के निर्माता डॉक्टर अंबेडकर जी इस संविधान को बनाने में उनका जो योगदान रहा, उसका तो बखान बहुत बार हो चुका है। लेकिन जिन परिस्थितियों में उन्होंने इस संविधान की संरचना की, जिन प्रभावों के अंदर रहते हुए इसमें जो उन्होंने प्रोविजंस दिए, उनमें एक सुदृढ़ राष्ट्र बनाने की क्षमता हमारी न्यायपालिका ने डाली है। इस संविधान का सबसे इंपॉर्टेंट जो प्रोविजन है, जिसको बेसिक स्ट्रक्चर से भी तुलना की गई है, वो है प्रीएम्बल। अगर प्रीएम्बल को देखा जाए तो उसकी प्रीएम्बल की जो विशेषता है वो ये है कि ऑब्जेक्ट्स जिनके आधार पर देश चलना चाहिए वो उस प्रीएम्बल के अंदर दिए गए हैं। 42nd अमेंडमेंट में जो उसमें संशोधन किया गया, वो भी एक बहुत इंपॉर्टेंट संशोधन था, क्योंकि उसमें जो ऑब्जेक्टिव डाले गए वो देश की उन्नति और संपन्नता की तरफ ले जाने के लिए अहम भूमिका निभाते हैं। प्रीएम्बल में जो वर्ड्स लिखे हुए हैं उनका सिग्निफिकेंस सब्जेक्ट मैटर रहा है इंटरप्रिटेशन का, लेकिन उसमें जो सबसे पहली चीज लिखी गई है, टू सिक्योर टू ऑल इट्स सिटीजन्स जस्टिस, जिसका दायित्व हम सब लोगों के ऊपर है और जिसमें अधिवक्ता परिषद का एक अहम भूमिका प्रदर्शित होती है। अधिवक्ता परिषद जो काम कर रही है उसको शब्दों में बखान करना बहुत मुश्किल है, क्योंकि इस तरह का भूमिका निभाने वाले बहुत कम ऐसे संगठन हैं जिन्होंने इस तरह की जिम्मेवारी ली है। मैं कहना चाहूंगा, इसमें कोई अतिशयोक्ति नहीं होगी, कि अधिवक्ता परिषद ने जो काम लिया है वो काम है जिसको प्रीएम्बल के ऑब्जेक्टिव रूप में कॉन्स्टिट्यूशन में प्रस्तुत किया गया है। टू सिक्योर जस्टिस and liberty, which also is a part of justice, and equality, which also is a part of justice, and above all fraternity, which is the main objective of Adhivakta Parishad. So in a way, Adhivakta Parishad is representative of objectives of the objects which are mentioned in the preamble. This is my feelings about the role of Adhivakta Parishad. I will now try and address by making some observations in respect of the aspects for which the function is being organized. That is, the aspects which pertain to service matters, service-related aspects. Service-related aspects are also taking their roots and guidance from the provisions of the Constitution, including the preamble. After the preamble, the provisions which concern service matters are primarily Articles 14, 15, 16 and 21 of the Constitution. Article 14 is such a beautiful article which is limitless and boundless in furtherance of the objectives enshrined in the preamble, and its interpretation by the courts has given it different facets and newer concepts. Sometimes I think that the entire gamut of service law can be governed by only Article 14 and nothing else. Because Article 14 talks of equality. Essentially, it talks of that there should not be any discrimination. It says that everything should be done in a manner which is reasonable. It also says that it should be completely in sync with the aspect of fairness. Fairness, reasonableness, non-arbitrariness, non-discrimination, they all together go to constitute equality. And therefore these facets of equality are seen in the other facets which concern the service matters and other fundamental articles also. In fact, there have been judgments which say that Article 14 is the main bowl of governance, and other articles of the Constitution are only different and specific expressions emanating from the same article. And that interpretation of Article 14 is completely flawless and absolutely true. Now, when we go to the court in relation to service matters, the aspect of equality arises when there is a discrimination, and also in certain principles when the equality is violated. For example, some person who is junior and is promoted, then that is violation of Article 14. When two persons are treated unequally, even though they should be treated equally, that is a facet of discrimination. Most of the cases which we fight in the courts, and specifically the tribunal, are based on violation of Article 14, and then it becomes Article 16 also, because opportunity or equality of opportunity is another article which insists on equality, but in terms of at the time of grant of opportunity. this also is a facet of Article 14 itself. If an opportunity is given to one person and the other person who is also entitled to be given that opportunity is not given that opportunity, then we say Article 16 is violated. Article 15 in certain ways also is a facet of Article 14, but the objective of that is in a different manner, that there should not be discrimination on specific aspects. It's another aspect of classification. As you all know, Article 14 also says that two persons should be situated similarly, should be treated similarly. But there is a concept of classification. To understand whether the persons are similarly, exactly or really similarly situated or not, then issue of classification comes. If it is a proper classification which is valid, it is a proper classification on the basis which is reasonable, and then it has an object to be achieved, then only classification can be done. You can constitute different classes of same persons. In the absence of which, violation of equality is not permissible in law. So I think 50% of the litigation in the courts in the public service field is handled on the touchstone of Article 14 and 16 only. Violation of Article 14 and 16 should normally take care of the grievance of the person whose fundamental rights guaranteed under Articles 14 and 16 are violated. But when it comes to the question of livelihood, we invoke Article 21 also, because employment is a facet of service and employment is the guarantee of livelihood, and when employment is impacted by adverse action, then the livelihood also is impacted. Therefore, we invoke that by virtue of violation of these rights, my livelihood also is being taken away. I am deprived of my livelihood. Right to life and liberty is also violated. Dignity is also violated. Therefore, an action which violates these facets of life should not be tenable or should not be held to be sustainable in law. Therefore, most of the facets of service law in the public service field, which is being handled by the CAT, is within the contours of these 3-4 articles. As you all know that there is a hierarchy of legislation. The most fundamental and highest legislation is the Constitution of India. The next in line in the hierarchy comes the enactments made by the Parliament, which is also has to be in conformity with the concepts of constitutional principles. Otherwise, again, their virus is tested in the context of violation or non-violation of these very articles itself. Then comes the next hierarchy, which is in the form of rules and regulations which are enacted under Article 309 of the Constitution. You all know. Article 309 provisions which are enacted under this article also have to be in conformity with the principles of fundamental rights guaranteed in Article 1461, because they are subservient, they are inferior in hierarchy, and they have to conform to the hierarchy of those, which in turn have to again be in conformation with the hierarchy of the constitutional principles and the provisions of law. Rules cannot be sustained if they are not in consonance with the provisions of a particular act. Constitution, acts, rules, then comes the hierarchy of administrative instructions, which are also issued by the governments in exercise of the powers vested in it, which is fourth in line of hierarchy. They also have to be not infecting the rules or the provisions of the Act or the Constitution. Then comes the last thing that comes in the hierarchy is guidelines, which are issued in the form of circulars or guidelines. So our service jurisprudence is regulated by this hierarchy also, in addition to the other provisions. If an action which is not in consonance with the hierarchy in this manner, then we go to the court saying that the action is illegal. Article 309, the provisions which concern the service law are Articles 310 and 311 of the Constitution. 310 says doctrine of pleasure, which was the doctrine which was prevalent before we attained freedom and before the Constitution came into force. But fortunately, there is an exception which is carved out to Article 310, which is in the form of safeguard and protection, that a procedure is prescribed in compliance thereof only an action can be taken against a person who is discharging duties as a public servant. That guarantee has gone a long way in protecting the interests and protecting the freedom of work to the public servant who are employed by the government, and many cases have resulted in that a wrong done by a superior authority out of extraneous considerations or vindictives are not allowed to cause injustice to a person and compliance with Article 311 is ensured. This compliance is available, fortunately, by the interpretations in the famous judgment of Purushottam Lal Dhingra onwards, even to the temporary servants. Vindictiveness and arbitrariness, reasonableness, fairness, which are repositories under Article 14, are also included in this to prevent injustice to the public servants. Then I come to the next article, which is 323, under which the Central Administrative Tribunal has been set up. The provisions whereof, including the rules, have opened up a new field of work culture so far as advocates practicing in the service field are concerned. Earlier we used to go to the High Court. When the tribunal was constituted, there was litigation which questioned the virus of the enactment that was upheld, and fortunately in the L. Chandrakumar's case, the original jurisdiction has been preserved in the service matters concerning the civil posts or the service matters or recruitment matters concerning the government or the agencies which are notified, as a result whereof most of the litigation on original side is handled by the luminaries practicing in the tribunal, which I can see all of them have contributed immensely to the development of law, and as a result whereof most of the burden of litigation in the service field has been lessened, and we have seen some speed happening in the decision making process of the service matters, and we have seen the different phases of CAT, but fortunately timelines for the adjudication of matters as of today are much lesser in comparison to the timelines available before the judicial forums, and I compliment this situation, at least in Delhi, to all of you, that you are doing wonderful service to the field of service law. Now I'll touch upon certain aspects of service law which have seen the maximum litigation so far, which I have also waded through from the beginning. The most ticklish situation which used to happen at the time when I joined the profession was adhocism. Wholesale ad hoc employments used to take place. And ad hoc employment hardly was through the process which was prescribed, and there was some element of discretion which sometimes was used and sometimes was abused. And ad hoc employments were the common feature happening all over. As a result whereof, the employees were being exploited and the protections were not available to them, and lots of litigation happened when the matters were taken to the courts saying that ad hocism is not tenable and sustainable in the eyes of Article 14, in the case of Article 14 and 16 of the Constitution, and regularization should happen. Until 2005, the prominent feature of regularization was a great solace to the persons who are employed on ad hoc basis, and thousands and lakhs people, persons, employees got the benefit of regularization through the mechanism of judgments, including Pyara Singh, starting from Pyara Singh, Justice Kuldeep Singh judgment, which said that 2 years is the maximum period you can keep a person on ad hoc basis, and thereafter a person is entitled to the regularization. The Harvard employees, PNT employees, etc., DTC Mazdoor Sabha, etc., there were many judgments, and there was some solace with regard to the aspect of exploitation who were being exploited in the name of ad hocism until the judgment in Uma Devi came. Uma Devi's judgment came to constitute a watershed, which judgment, according to me, the objective of which was that there should not be any ad hocism. But most of the time I see that the judgment is being seen in implementation that there should not be any regularization. They say that the judgment refers to one-time measure as a form of regularization to those who have continuously worked uninterruptedly without break or without the assistance of the court or others for a period of 10 years. I do not understand the logic behind 10 years, but it's a judgment of the Honorable Supreme Court. That also the Constitution bench, rightly or wrongly. The judgment governs the field and is binding on all courts below. But the regulations have stopped thereafter to a great extent, which in my view is not the correct thing to happen, because if you stop regularization of that judgment or in the light of that judgment, then you should stop making appointments on ad hoc basis. The main objective of the judgment was that you should stop making ad hoc appointments. But ad hoc appointments I see are happening and continuing, and on the contrary, it has been converted into a new concept which I do not know as a lawyer practicing on the service side what is the legal or constitutional basis of engagement on contract basis. What I see as a miscarriage of justice is more and more engagement of contractors who would engage employees and would provide service to you, particularly in the PSUs. In the light of the mandate of Article 14 and 16, I think that this mechanism is not good for the citizens, to the employees or the employers, because all of us know that the beneficiary in such a situation is some third person, middleman, as a contractor. बचपन में हम जिस कल्चर में पले बढ़े उसमें तो ठेकेदार को भी कोई बहुत अच्छी नजरों से नहीं देखा जाता था, तो ये ठेकेदारी ठीक नहीं है, because we can see the exploitation of the persons who are on contract basis or ad hoc basis. Therefore, I would urge all of you to try and see whether my point of view about Uma Devi is correct or wrong, whether the employment on an ad hoc temporary contract basis is justified and should be allowed to be continued in the face of Article 14-16 of the Constitution. I still hold the view. In fact, the Honorable Supreme Court has subsequently also directed one-time measure to be adopted for regularization to those who have completed 10 years of service in many more cases. But some views have been taken that that was a one-time measure, and one-time measure does not mean repeated measure. Therefore, I request all of you to put your efforts in that direction and contribute to ensure that the citizens of this country are not exploited by the mechanism which has been frowned upon even by the Constitutional Bench, that it is a backdoor entry, it is not good, it should not be done, it should not be done. Rightly or wrongly, the practice is prevalent as of today. Next aspect which concerns service matter is resulting in litigation is seniority, which according to me also is protected. Senior junior principle also finds its basis or roots in Article 14 itself. Seniority should not be violated because it's unreasonable, it is wrong, it is erroneous, etc., etc., etc. Now, seniority disputes started immediately after 1959, and first judgment maybe which I recollect of was S.G. Jessingani. These disputes have continued unabated. And I find it interesting that these disputes are mostly between those persons whose means of income or whose status is higher. And courts have been clogged with the litigation concerning this, which baffles my mind. I am unable to understand. Seniority in simple words, simple meaning, simple language means कि भाई जो पहले लगा है वो सीनियर है, जो बाद में लगा है वो जूनियर है. उसमें कोटा का प्रिंसिपल रूल्स ऐड करके और उसमें कोटा का रोटेशन है या नहीं है वो करके चलते जा रहा है. दिस इज बिकमिंग अनएंडिंग. In my view, most of the litigation with regard to service matters in seniority related aspects can easily be handled by making it simpler and by ensuring that rules which are enacted by different departments concerning seniority or quota rota system itself, etc., are aligned in a manner which results in less litigation, less hard burden. Because most of the time courts also observe that employees should be seen to be working in the offices and not spending their time in the courts. ये dispute एक ऐसा है जिसको कम किया जा सकता है to a great extent. But unfortunately this has taken different contours and complexions, starting from Jessingani, then came the cases of Janardhan, etc. Then for a long time the case of Parmar continued to hold the field, and now Mehr Chandra, and after Mehr Chandra another case also has taken a complexion which says that no, Mehr Chandra is not correct, here and Parmar is correct. The premise of the latest decision is Maverick Cotijo, which is a 5-judge bench which says that quota rota is good. As I see from a distant perspective, it is a complete full circle that has come from quota rota starting from 1959 inspections till today. Where it will go, what will happen, nobody knows. But something should be done to avoid this litigation and to ensure that senior gets seniority and junior doesn't get a result of supersession of the senior. So you need to hash out the principles. When ad hoc is reminded in the context of seniority, 5-judge bench in All India Directive also lays guidelines that ad hoc, when without any break results in regularization, then the benefit of seniority should be from the date of initial appointment. I don't know, my brother Sanjay and my esteemed colleagues would be in a better position to understand this. But normal rule of seniority as length of service should be the predominant rule, which would give a sense of satisfaction to the employees who are likely to be superseded, because we all know most of the time the rota quota is not followed for different reasons and vested interests come into play, as a result whereof public interest suffers, resulting in litigation. वो ठीक टाइम पे क्यों नहीं अपॉइंटमेंट हुआ, ठीक टाइम पे रिक्रूटमेंट क्यों नहीं हुआ. परमार सेज initiation of the recruitment process, initiation of the promotion process. All these interpretations and contours in my mind, you can solve these kind of riddles. I have not been able to solve these riddles, but that is an aspect which concerns all of us, which should be seen to be resolved in a proper manner, and for which we can contribute a little. Next aspect is with regard to service matters is disciplinary proceedings. So far as disciplinary proceedings are concerned, there is one aspect which I, despite my experience at the bar, have not been able to reconcile and understand. Penalty proceedings emanate on the basis of some charge sheet, for which the decisions say that there should be a time limit, but we all know and we all have seen that disciplinary proceedings take years and years and years and years. And ultimately, either they result in exoneration or they result in punishment. What should happen to those years which have gone by? What to do about it? If the person is exonerated, will he get restitution of all his rights or not? Is the concept. Whether the process of seal cover procedure is a safeguard for the purpose of ensuring that the person doesn't suffer, or it is a futile principle which doesn't help the person. I think the solution to that again would be to make it time bound and then lay down in clear terms as to what would be the consequence of the final culmination result of the proceedings, disciplinary proceedings. If a person is exonerated and found to be not guilty, then he is entitled to his due in every manner. But if otherwise, then he should not be basically rewarded by the length of the proceedings. A person who deserves to be removed or dismissed or penalized should be done speedily. A person who deserves to be exonerated should also be exonerated speedily. I think we should all ensure that so far as aspects of disciplinary proceedings are concerned, सीनियरिटी वगैरह तो फिर भी थोड़ा सा डिले अगर हो तो अफोर्ड कर सकता है, लेकिन डिसिप्लिनरी प्रोसीडिंग्स के मामले में स्पीडी डिस्पोजल, स्पीडी कंक्लूजन इज वेरी इंपॉर्टेंट. Courts have said that 6 months time should be the final time, 1 year time should be the final time, but hardly there is any implementation or enforcement of these kind of provisions, and a person becomes helpless and disenchanted. So these are the aspects which concern the disciplinary proceedings, which play an important role in the governance so far as service period is concerned. Now I have some musings to share with the colleagues and esteemed members here, that there should be, now I'll touch upon the aspect of Advocates Act, because Constitution, after celebration by the judgment under Article 360, 370 of the Constitution and deliberating upon service, I feel like touching upon the aspect of Advocates Act. We are all advocates, and as advocates, we have some duties and responsibilities. And by the recent development of the government in initiating amendment to the Advocates Act, I feel compelled to share with you that the government is driven to address the aspect of toutism in our profession. It has become so important that it needs to be addressed by the government by making a law that indicates that there is something which is wrong so far as our profession is concerned, Advocacy Act emphasizes on the ethics, on the responsibility, and it is supposed to be a noble profession. So this move of the government in introducing amendment to the Act should make us deliberate and reflect over ourselves also, because the object with which Adhivakta Parishad is taking things in the right direction, and your all members, concerns us also. There should be some mechanism whereby the nobility of the profession is maintained, and there should not be any necessity for the legislative intervention so far as our working is concerned. I think towards the discharge of our duty or responsibility as an Advocates Act, I feel that there should be some mechanism of doing some service whereby our nobility is restored. वो कॉर्पोरेट सोशल रिस्पॉन्सिबिलिटी का एक कॉन्सेप्ट है जो बिजनेसमैन भी करता है, हम लोग तो प्रोफेशनल्स हैं. Adhivakta Parishad and other persons who can do something in this matter should consider introducing the concept of social responsibility on the advocates also. They should devote their energy, their time, their skills to do some social responsibility work. As a result thereof, the mechanisms can be developed, they can contribute in mediation. मेरे को लगता है कि सर्विस मैटर्स में भी आधे से ज्यादा सर्विस मैटर्स तो अगर ठीक गाइडेंस मिल जाए कि कौन गलत है कौन ठीक है तो रिजॉल्व हो सकते हैं. जैसे एक जज साहब ने कहा था कि both the sides know the truth, it is the judge who is on trial. तो एडवोकेट्स अगर ट्रूथफुली कोशिश करें तो आधी से ज्यादा चीजें रिजॉल्व हो सकती हैं. उसमें पब्लिक सर्विस के कॉन्सेप्ट में मेरे को एक जो विचार मन में आया जो मैं शेयर करना चाहता हूं. अगर एडवोकेट्स की सर्विसेज सारे गवर्नमेंट डिपार्टमेंट्स या पब्लिक सेक्टर अंडरटेकिंग्स में एक मैकेनिज्म हो जाए कि वहां पे एडवोकेट्स आएंगे एक घंटे के लिए या 2 घंटे के लिए और सर्विस रिलेटेड जो भी उनके एस्पेक्ट्स हैं उनको गाइड करेंगे और उनको मीडिएट करके समझा के रिजॉल्व करेंगे कि भाई अफसर की गलती है या सबॉर्डिनेट की गलती है, ये ठीक हो रहा है या गलत हो रहा है. इस तरह की एक सोशल रिस्पॉन्सिबिलिटी का डिस्चार्ज काफी हद तक पब्लिक इंटरेस्ट कैटर कर सकता है. तो हम लोगों को कुछ ना कुछ अपार्ट फ्रॉम लीगल एड हम लोगों को कुछ तो सोचना चाहिए कि एक सोशल रिस्पॉन्सिबिलिटी टुवर्ड्स द नोबल कॉज ऑफ आवर प्रोफेशन वी शुड थिंक ऑन दोज लाइन्स. लास्टली I think I need to touch upon the aspect which goes to the core of